Morning, Judge. Nice to see you.
Morning, nice to see you.
The way we're going to proceed this morning is each of the commissioners will introduce themselves. We have one commissioner who can't be here in person. She's on the speakerphone. After we do that, you'll have 2 or 3 minutes, 4 minutes, to make any opening statement you think, comments you'd like to make. I'll be the person asking you questions. I'll do that for about 20 minutes. I'm also the timekeeper, so I'm going to turn myself off after about 20 minutes, and other people get to ask questions also. And then you'll have 2 or 3 minutes wherever you need to make some closing remarks.
All right, thank you.
So, go ahead.
Good morning, Your Honor.
Morning.
Vincent Citro, the law offices of Horowitz and Citro.
Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Bardos with Craig Robinson.
Good morning, Judge. I'm Michael Sasso of Sasso and Sasso, and I have Commissioner Amanda Perry Carl here by phone.
Morning, Ms. Barrow.
Good morning, Your Honor. Brett Renton with Schatz & Bowen in Orlando.
Morning.
Nice to see you, Your Honor. Petra Brownlee, the Brownlee Law Firm.
Morning.
David DeArmas, Kramer Price and DeArmas.
Morning.
Your Honor, Scott Thomas with Burn Foreman.
Morning. Well, first I want to thank all of you. I know that this process, you have to devote a substantial amount of time to going through this process for myself and all the other applicants. So I just want to commend you for your performance of this very valuable service. I believe that serving as a judge is a calling. I also believe that I'm called to serve in a capacity where I can use my abilities, my philosophy, my education, and experience to provide the most benefit to our community. I've applied for this position because I humbly believe that I can fulfill my calling by serving on the 5th District Court of Appeal. I look forward to answering all of your questions during our time together here this morning.
Thank you. I'm going to begin by asking you a little bit of a personal question. I didn't realize this until yesterday when I reread this. You were born in Honolulu.
I was.
How did you get from Honolulu? Were your parents in the military? Or?
My father served in the United States Navy, and he was stationed in Honolulu. So that when I was born, soon after I was born, he decided not to re-enlist. So he and my mom and me moved to the Mayport Naval Base around the Jacksonville area.
Sure.
So I came there in the early part of 1967, I believe. So what my mom tells me, I don't remember it. But that's the farthest north I've ever lived, and been in this great state of Florida ever since.
Okay, thank you for that. In your application, you talked about working at Grace Church, First United Methodist Church, as a co-chair of Student Ministry Leadership Committee. I'd be curious to hear about that.
Well, recently, my wife and I joined Grace Church. We were members of the First United Methodist Church for many years, but recently.
So that's 2 separate churches. I'm sorry.
It is.
I got it mixed up. Okay.
No, it's okay.
I'm interested in the student ministry.
Sure. So for both churches, I'm serving on the student ministry. Actually, this past Sunday, we started the new academic year, serving as a volunteer for high school guys, small group leader, and volunteer for the student ministry. I just started with our new church. Prior to that, when we were members of the First United Methodist Church, I served in a similar capacity for a similar ministry, again, for high school students, although at my prior church, there were some years during my service where they were split by gender, and then other times they were co-ed, but always working with high school students. It's really, I consider that a blessing in my life. My wife and I don't have children, but I felt called to serve my church and the youth of that church in that capacity. I really enjoy it.
You know, I got to ask you about Orange County versus Rick Singh. I was very interested. I was happy to see this happen. For the other commissioners who may not be familiar with the case, would you mind just giving a thumbnail sketch of your decision? And what happened was the Supreme Court issued a mandate and reversed themselves.
All right, well, I go into some detail in my application, so I'll just try to make this very much of a thumbnail. But in essence, there was a ballot item that was approved by Orange County, placed on the ballot, approved by a substantial majority of voters, that did 2 things. Impose term limits on the constitutional officers, sheriff, tax collector, property appraiser, et cetera, and 4 consecutive terms, and then also made those elections nonpartisan. A challenge was filed against that, and there was a threshold standing issue because two of the constitutional officers at first tried to bring suit in their official capacity. I researched that issue and ultimately granted Orange County's motion for summary judgment that they did not have standing, finding that they did not have, under the applicable case law, the personal interest necessary for them to sue in their official capacity, because nothing in the ordinance did anything to diminish or demean the duties or powers of the office. It was strictly their personal interest. After that, they then substituted in their individual capacity, and so the case proceeded on the merits. And I rejected several of their arguments about single subject rule and some notice arguments. And really the beef of their argument that I did uphold in part was as to the nonpartisan aspect. With respect to the term limits, there's a Florida Supreme Court case that really is right on point.
Yep.
They seem to recognize that is something that Orange County could do, and so I held that that was valid. But with respect to the nonpartisan aspect, there had been a Supreme Court decision that had found that the legislature had not expressly or implicitly preempted the field of election law in a case, I believe, that came out of Sarasota County. The immediate following legislative session, the legislature enacted a very simple, clear, unambiguous provision that said, we preempt to the state except as expressly provided by law, otherwise everything addressed in the election code, which included, but was not limited to, Chapter 105 dealing with nonpartisan elections. Nonpartisan elections, I read that language, it was clear and unambiguous that it applied to judges and school board members. Did not provide for constitutional officers, and so ultimately I found that was preempted. Orange County can't do anything to the contrary, and I invalidated that portion of the ordinance. It was affirmed by the 5th District Court of Appeal as to on all issues, both by the appellants and the cross appellant, and then went to the Florida Supreme Court, and not many judges have been both reversed and affirmed by the Florida Supreme Court in the same decision within the course of 90 days, but that's exactly what happened. At the very beginning, before the governor was inaugurated, what I'll call prior Supreme Court, 4-3, reversed the 5th District Court of Appeal. And
Why?
they reversed because they found, I want to be careful about what I say. I believe that opinion was it was disingenuous. To read, they found that preemption language did not
Say what it said?
do what it
Didn't preempt.
didn't preempt.
Right.
I mean, I really don't know another way to say it, to be honest with you. And I wasn't saying that because it was reversing me. I just thought that it was a poor decision. But it was 4-3. After that, and they also, in their opinion, said no motion for rehearing will be entertained. And I would like to say on that, I've told people that if I ever, as a judge, reach that level of arrogance where I'm so certain of my opinion that I want someone to tell me. And I mean that. But that's what they said. And so,
Does that maybe show a lack of certainty in the opinion, by the way?
I don't know. I don't want to
Okay.
read between the lines, but the lawyers, being professional lawyers, they followed what the Supreme Court said and instead filed a motion, not for rehearing, but to recall the mandate and for clarification, which ultimately, approximately 3 months later, was granted. The motion to recall the mandate. The mandate was recalled.
Jeez.
The opinion was vacated, and a substituted opinion, this time 6-1, affirmed.
Got it right here.
Fascinating case.
It is
I had
fascinating.
never done anything with election law that was
Yeah.
completely outside my wheelhouse as a lawyer. Had not had a case like that as a judge. But that case was fascinating. I believe it prepared me well to serve as an appellate judge. I had a law clerk specifically assigned by the graciousness of Judge Lawton. He gave me a dedicated law clerk to help me with that, doing some of the research. I worked with her to prepare the orders and to do the analysis, and it was a fun case.
Yeah, you did a great job on it, too.
Oh, thank you.
I feel like I'm hogging all the time. I'm gonna open it up to my
What's the
phone.
site like?
There you go.
Thanks.
It's a fascinating case. Yeah, you got it right.
Well,
According to
Eventually.
one.
Eventually.
So what are your thoughts on PCAs in non-criminal matters?
in non-criminal matters. I believe that if an appellate court is going to write, it's because the court believes there's something meaningful to be said. I think there can be a danger just writing unnecessarily. But if there is a conflict that's raised or an issue of clarification that is raised, and I would say preserved. I recently sat for Judge Eisnagel in July, and we had some very interesting civil cases, but the interesting issues that were raised on appeal were not preserved below, and we did not address them, so they were PCAs because they were not preserved. But if they're preserved and there is uncertainty, I think that's what appellate courts should do. They're there to tell people what the law is so that people can govern their conduct, make business decisions, make life decisions, and do the things that citizens do when they're aware of the law. But if it's not necessary, I think the flip side, the danger is when you write on something that's really already been addressed, you could unwittingly create issues and confusion.
At the risk of cross-examining a judge, would it not help the litigants to know and the judge and the lawyers to know that the reasoning for the decision was based on lack of preservation of the issue as opposed to you're wrong on the issue?
It may, and I will just say there's also, in a civil case, myself, unless I have to do something like that, I would not want to point out to a lawyer's client that maybe error had not been properly preserved, unless I had to.
Well, what about in the context of criminal cases then? If you did speak on the issue and state that the error wasn't preserved, wouldn't it, or what do you think, I guess, back in the trial court, would it make it easier, when the follow-up 3850 comes along and they say, my counsel didn't object to this, wouldn't it be beneficial to a court to have an opinion from the Fifth saying we would have ruled on it, but we didn't because nobody objected?
Well, I certainly agree that if the issue itself of how do you preserve a certain issue needs clarification, then that should definitely be addressed. If, for example, there is case law that says if you do X, Y, Z, you're preserving this issue on appeal, then certainly I think that if there's going to be a change in that or a clarification of that, then that should be addressed. But I myself, I just have a philosophy of restraint, and with respect to a 3850, I wouldn't want to raise issues on a 3850 that haven't been briefed and presented to the court in a 3850 context.
Thank you. With regard to writing often, and if it creates confusion or could murky the waters or something like that, what do you think about Florida's courts issuing PCAs versus the 11th Circuit and how they write in every case, but they just have certain opinions that are published and unpublished? Do you think that their way, that's a good way? Were you aware of that? Maybe I'm catching you off guard with that.
A little off guard in the sense that, when I practiced, this was a long time ago, but when I had a couple of appeals to the 11th Circuit, they were PCA. I am familiar and I have seen that sometimes they will write an opinion but state this is not for publication and it's not precedent.
Yeah, they either publish or unpublish it. So if
Okay.
they're willing to, and then the ones that are unpublished would be persuasive and not binding.
Mhm.
So, I mean, do you think that that would be a good way to sort of balance what's going on between writing an opinion and issuing a PCA?
I mean, I haven't really thought about that, that's interesting. I mean, I think if that's something that went through the appropriate process and after input from all the stakeholders, they thought that that was what the appellate courts should do, then I certainly would abide by that.
Your Honor, we saw you last December, and so for a lot of these questions, we recently have information, and of course your updated application, but how would you say that you have made yourself more competitive to get this vacancy since we last saw you?
Well, one we already touched on, which is the opinion that came out in the Sing v. Orange County. And in addition, on the criminal side, I handled my first capital case in June. That's also in my application. That's the case against State v. Nelson. That, I'll say without equivocation, was the most emotional and intellectually demanding case I've ever handled. It was a privilege to handle it. I have never been more filled with a feeling of humility, both in the fact that there was a victim's family that had suffered terribly. It was somewhat in my hands. And a man's life was in my hands. It weighed very heavily on me, and it was motivating as well as being humbling. And also made me incredibly proud of both the jurors in our community, the seriousness with which, when you did individual voir dire, which I thought a med mal case, the jury selection was a challenge, but this made it pale in comparison because of the individual voir dire. But the seriousness on every juror's face it just filled me with pride that they understood the gravity of the situation, the way they interacted with the lawyers, the way they addressed the questions, and then also behind the scenes. My colleagues, my wife, my friends, without their support, I never could have gotten through that process. But it was a privilege. It was difficult. I'm glad I had that opportunity, and I'll leave it to you to talk to others, and you can watch it on court TV if you're so inclined. Let you be the judge of how I handle that case.
Judge, I've heard you say that the Sixth Amendment just states simply that we have the right to counsel, but not the right to effective counsel. And I'm wondering if you can touch on if, am I correct, Your Honor, in saying that you don't believe, because the right to, the word effective is not written into the Sixth Amendment, that we should not read that into it? I don't want to put words in your mouth, so if you want to touch on that first, and then I'll follow up.
I'm not persuaded that the Sixth Amendment, based on the cases that I've read, that the Sixth Amendment provides for a right to effective counsel.
Okay, so can you touch on, okay, then what do we do, the workability of your interpretation of it? So if no one had, this would have an impact on 3850 claims where someone fails to object, fails to preserve an error, fails to make a certain argument before the court. Do you think then that the language, the right to counsel, is just hollow?
No, I don't think it's hollow. And first of all, and this is, I do enjoy talking with this.
Yeah.
We've talked about this before. It's an interesting academic issue, but that's my personal reading of the Sixth Amendment.
Mm-hmm.
However, above that is my belief that God calls me to submit to higher authorities. And the U.S. Supreme Court has answered that issue. Until they change it, or the Florida Supreme Court changes it, I'm going to follow the law. I do agree with Justice Thomas, however, that it should not be expanded. And if I can, in an intellectually honest way, on the Fifth District Court of Appeal, write an opinion that does not expand it, then if I'm persuaded that it's true to the text, then I would do that. However, if the issue has been addressed and it clearly falls within the scope of the right to effective counsel as defined by current law, that is what I'm going to follow.
Thank you.
Anybody else? Your Honor, you have a few minutes to make any closing statement you'd like to make. Appreciate you going up there.
Sure. Well, I again want to express my appreciation to you for your service and for considering me for this position. As I stated earlier, I humbly believe that I can best serve our community as a district court judge. And after considering my application, the comments from my supporters, and my answers to your questions here this morning, I hope that you will do me the honor of selecting me as one of the nominees for this vacancy. Thank you.
Thank you for applying.
Appreciate the vote. We have